computer. So, Introduction and Principles of Liability in Tort, which is Module 1. Now, we have discussed a lot yesterday. More than 2 hours we have discussed about what is tort, how it is lying between the criminal and the civil jurisdiction of law, why it is a vital area, how it fills up the gap, how it provides a resolution from the perspective of civil wrong, how it provides individuals with a mechanism for seeking remedies for the harm caused to them or because of any unreasonable conduct of others. We did understood what is the difference between different uh, kinds of laws, like difference between quasi-contract, contract, and civil. The principles of liability in tort cover a broad spectrum of interaction, and that can encompass the disputes arising from negligence, intentional wrong, and strict liability, what we discussed yesterday. Now, this lecture today will explore first of all, how the development of the tort actions in England and India has happened. Now, as we know, all our laws basically are originating. The procedural laws are, the basic laws are coming from, all of them are coming from England. So that is why, to trace back the history of the tort, we have to go back and trace back in the historical background with the development of the tort actions in England first. Now, it can be traced back in England to a common law. It used to be called common law, where legal actions arose from wrongful acts that caused harm, but were not considered something as a crime. So they were all called as common laws. So its historical background sits in the common laws. Now, initially the torts such as assault, trespassing, defamation were something which formed the basis of the civil claims. Over the centuries, when the landmark cases laid the groundwork and the modern laws started to pick up, the tort law started to shape up after that. So particularly when establishment of negligence as a primary case of tortious liability started, marked in certain very famous cases in England, like Donoghue versus Stevenson, 1932. Let me write it here for you. Donoghue versus Stevenson. And this is a case of 1932. So this is one of the landmark judgment which started to come, which we'll talk a bit in a while, which introduced the neighbor principle in negligence law. So what this case law brought was a neighbor principle in the negligence law. Over time, when it started to develop in India, when we started to shape up our own laws, it was significantly influenced by the British common law, what was transferred us during the colonial period. So during colonial period, we started to pick up from the British laws. Post-independence, when the framework started to evolve around the constitution, what we created. So the constitution is something which drives and which shapes up any law, any act. It cannot be going against what is the framework of the constitution. So based on that, when we started to shape up our framework of laws, so it mandated the protection of fundamental rights also. So this was also which was added apart from the common law principle, which we inherited from the English laws. So very famous cases were MC Mehta versus Union of India in terms of Indian tort cases development, and this is a case of 1987. And this is something which is related to environmental tort. We spoke yesterday, like there are some 2, 3 very special new torts which started to evolve in India. One is even right now, which is in high focus, is the environmental, chemical pollution, and cyber related. So this was related to environmental tort and reinforced the liability principle with the public interest framework and talked about strict liability. Now, let's talk about the first case law, what we mentioned from the British background perspective, which is Donoghue versus Stevenson, 1932. So Mrs. Donoghue consumed a ginger beer, a ginger ale, containing a snail. So it has a snail inside, which caused her illness, of course. And she sued the manufacturer for negligence. So there wasn't any contract between her and the beer manufacturer. There was a wrong which had happened, and to which she looked into a civil side of the remedy of getting the compensation for the health issues. So the legal reasoning which was given that point of time by the House of Lords, which decided the matter that point of time, they established that manufacturers owe a duty of care. We spoke about duty of care yesterday. So duty of care, if it is not done, it leads to tortious situation. So the House of Lords said the manufacturers owe a duty of care to consumers, even if no direct contractual relationship exists. And the judgment said the court then finally ruled in favor of Mrs. Donoghue, setting a precedent for the consumer protection against negligence in the history of common law, later shapes up into the law of torts. So this is how the history of the tort started in the rooted in the British laws. Then we talked about the case example India called MC Mehta versus Union of India, MC Mehta versus UI, you can write, 1987. And this is related to environmental pollution from industrial activity. So the industries were throwing polluted water in the Ganges River, which was challenged in the court, and affecting the livelihood of the local communities also, because the water is polluted. Then a lot of resources which were extracted from the water, like fisheries, etc., and the related other things like farming from that water, etc., everything was impacted. And that is how it motivated this to be taken up in the court. And the legal reasoning what Supreme Court has provided in this, that the Supreme Court has recognized the need for strict liability for industries causing environmental harm and emphasizing the need for accountability in public health matters. So that is where the legal reasoning was sitting, and the judgment said the court ordered finally measures for pollution control. So they prescribed in this particular judgment the measures for pollution control and for recognizing the right of healthy environment as a fundamental right. So this brought in healthy environment as a fundamental right to be provided. So that is how the history and the definition, the development of tort actions in England started with Donoghue versus Stevenson, and it set the first precedent in the history for the consumer laws in terms of negligence. We did mention something about a situation where even there can't be negligence yesterday, and if there is an injury, then also the industries are liable. So it is little bit further developed, but that point of time it was a negligence which was considered, and that is where it started the first landmark judgment and precedent for in the history of tort. While in India, the very first which could be picked up from the environmental side, a good example is MC Mehta versus Union of India, 1987. So chapter module 1 will be easier for us today because we have already gone through a lot of things yesterday while defining. Now, let's move to the second point, which is meaning and definition of tort. That is where we've spoken a lot yesterday, 2, 3, but we'll still go through it a little bit so that in a structured way, you get all the examples and the right case laws, etc. So meaning and definition of tort we spoke yesterday. It's a legally defined as a civil wrong, and which could cause a harm or injury to another one, and the remedy is sought for their harm to their property and their other legal liability which are coming up. For example, from psychological, mental side as well. And the essence of basically tort law is to provide more towards remedy. It is more inclined towards remedies to be provided, and where the individual's rights are also infringed upon. For example, there is no physical, though no mental harm happens. Even if a right is harmed, if a right is wronged also for a person, that right is taken away by somebody, then also in that case, if that infringement also happened, tort is standing there to support that person or support that situation. So this necessitates in spite of some of it lying in between or overlapping, as I said yesterday, between the criminal and the civil side of it, the tort side of it, basically depending upon how do you want to proceed, and depending upon the need, how you want to, either you want to go into criminal side of it or the tort side of it for the fulfillment of all the remedies to bring back you from the damaged situation to the redress to the normal situation. So the key elements of a tort, if we say in that way, is a wrongful act. So there should be some wrongful act which could be happen. Primarily, this is what it is said. There might be a situation where a wrongful act might not happen from somebody, obviously in obvious situations, but then injury has happened. So wrongful act, an action or omission. We talked about act and omission yesterday. That's the reason we spoke about it. That infringes on the rights of an individual or entity is called a wrongful act. So wrongful act is both an action or omission, which is presence of activity or absence of activity, damages and remedy. So these are the three key elements of a tort. So what are the three key elements? Wrongful act, damages, and remedy. So damages, whatever damages injury has to happen to physically, mentally, or even to the rights, and remedy. What remedies could be brought upon to bring you back to the injured party, back to the same state and get a relief out of it. Okay. So I'll give one example, say, which we mentioned yesterday also. For example, if somebody maliciously spreads a rumor about somebody which brings a wrong reputation, a defamation of the person, the party can seek compensation even for the harassment damages result to him directly or indirectly to his mental state, happiness, etc., etc. Or, for example, a delivery truck is there, which is parked and it goes, handbrake is not put and it goes and dashes with a car, or he's driving recklessly and he, dashes with a car. In either of the cases, a property is damaged. The car owner can sue him for the damages based on the tort concept. So this is seeking concept for repairing and all that, etc. If somebody is injured, his treatment, etc., could also be taken care using that. So that is basically what we talked about, the basic ingredients of a tort. Now, we move to point 3, which is tort distinguished from contract, quasi-contract, and crime. Let's talk about this once again. Very quickly, we'll touch upon because we've done it in detail yesterday. So tort versus contract, the very first thing distinctions is it is in nature the difference, right? So tort arises from a wrongful action independent of contract, while a contract can exist from an agreement between the parties with specific obligations as the terms and condition of that contract, while the liability, if we talk about the nature as compared to tort versus contract, this is what we said. But if we talk about the liability perspective, in tort, the damages which are happening are unliquidated. That is something which is the damages could be claimed when there is no contract, and based upon the actual damages, what happens. Whereas breach of contract, we have a measured contract and terms set forward for the damages to be completed. When we compared yesterday tort versus quasi-contract, quasi-contract basically is a contract which is not a true contract, as you know, and it is imposed by law to prevent any unjust enrichment to one party. So that is also something which is benefit at the expense of another party, what we can say. So in this liability quasi-contract focuses on preventing unfair gain rather than establishing liability for wrongdoing as seen in the tort. So this is also a basic difference as we discussed in detail yesterday. Tort versus crime, we believe in the nature of the relief how you wanted. It might be both a criminal and a tort situation, but in which side of the remedy you want to go ahead, which legal proceedings you want to follow with. That is how the tort versus crime is uh, differentiated. Now we talked about a couple of examples. So we talked about the example, if we talk about contract versus tort, we talked about a contractor which fails to complete a home, say for example, renovation as on time. So it's a breach of contract because the contract had a time factor and we wanted to have a time also to be considered one of the factors which is going to impact me if it doesn't happen. So in contrast, if the contractor accidentally damages during this particular activity of house renovation, something during using his tools, etc., of myself or my neighbors. In that case, uh, I can or the neighbor, whomsoever has got the damage, can sue. So that is a difference between contract and tort. The example. Tort versus crime. We talked about the person throwing a stone on the window of the neighbor, and the glass breaks the window. So either if you want to take a relief from the criminal side, you could take a relief from the criminal side, but the tort will help you to take the compensation for the breakage and the damages. So the constituents of the tort are the wrongful act, damage, and remedy, what we said. So wrongful act, which is something which is causing some kind of damage. The damage is actual harm or injury. It could be of any kind. And remedy which is formulated for the unliquidated damages, which is I'm going to ask for from the court to provide me that relief. So until this point of time, until this particular topic, we had discussed a lot in yesterday's session. So when we say wrongful act, it could be a intentional act or negligence. For example, if we talk about negligence, we can say a driver runs a car during a red light and he goes and rams into some person or some vehicle. That is a cause of negligence. While a defective product, etc., which is we discussed yesterday about a vehicle which makes an accident because the brakes were defective, the person can claim to the company for their negligence, irrespective of having no direct relation with the company or direct contract with the company. So until this we discussed yesterday. Now we'll go and talk about a new topic, which is topic 5, malfeasance, misfeasance, and non-feasance. This is a topic which we have not covered yesterday. So let's talk first about the definitions. Malfeasance means what? It refers to a performance of an unlawful act. So this is malfeasance is related to malfeasance are two words. It is referring to a performance of an unlawful act or a wrongful act done intentionally that cause harm. So any such performance of an unlawful act or a wrongful act done intentionally that caused harm is called malfeasance. So malfeasance involves action that are illegal or unethical and directly harm another party. Directly harm because it was done intentionally. So if somebody is done doing something intentionally, that particular person will directly plan it against someone or some parties. So that is why it is something which is done a harm directly to the other party. And now why this is malfeasance involves action that are illegal or unethical because it is something unlawful or wrongful by definition. So it has to be either illegal because unlawful or wrongful means something which is unethical to be done. So in any ways, this is malfeasance. Misfeasance, as the word differences from malice to mis. is occurs when a lawful act is performed in a negligent manner. So you have missed into this particular act to be done diligently. So occurs when a lawful act is performed in a negligent manner, leading to a harm. We gave our example of doctor yesterday. So misfeasance represents improper performance of an act that a person is legally allowed to complete but manages it in a way that results in harm. And as I said, the very clear example is of a doctor. So the doctor is supposed to do a surgery, do the remedy-wise surgery, and whatever has to be operated inside the body, he or she has to do that, close the body properly, seal it, and cover it for healing. But in between, this act which is legally the doctor is allowed, if the doctor leaves an instrument inside or leaves a towel inside, that's a lawful act was performed, but in a very negligent manner, and that is why it has led to a harm to me. And in that case, malfeasance, which is coming from a malice word associated with feasance, is something which is a wrongful or unlawful act, illegal or unlawful act, or a wrongful act which has been done intentionally to harm me. So malfeasance is out of malice done to hurt me, while misfeasance is something which is I went to go ahead and to complete something in the legal way. I ended up doing it in a wrongful way. So these are the two very clear differentiation, mal and misfeasance. Now let's talk about the third variety of this is called non-feasance. So refers to the failure to act when there is a legal obligation to do so. So the act part was malice initially, so malfeasance. It was missed in a way it was supposed to be done, and it was done in a wrong way by negligence. So it was misfeasance. Non-feasance, where I have a act to be done, which refers to the failure to the act when there is a legal obligation to do so. I was supposed to do that, I have not done that. So non-feasance often involves situations where inaction results in harm or injury to another party who depends on a duty of care. This also could be a medical case and other cases also. Let's talk about the medical case example where, for example, somebody is an accident victim. That person is bleeding profusely. The person is brought to the hospital for immediate attention of the doctor, and the doctor is supposed to immediately act on that patient and help that patient to get recovered fast and save his life immediately in that critical few moments where he is surviving and fighting for the life. But what the doctor unknowingly and whatever the reason of his omission of the omission activity, he is not taking care of that patient, saying, I need a police personnel to arrive, then only I'll touch the patient, which is wrong as per the laws. As per the prevailing laws, it is not required anymore. So in that case, what has happened is a non-feasance situation and the patient has passed away, or the patient has got into a critical situation, or he has gone into a coma, or gone into a vegetative state because a non-feasance has happened. So this is the clear difference, and the names, if you remember properly, mal, mis, and non, it will help you to understand what is the difference. So mal is done, you can remember malice. So out of malice, out of bad intention, I've done something wrongful or something unlawful to you, which is done by intention to harm you. While when I say misfeasance, I was supposed to do something properly, I missed it doing it properly, and it has landed to me in a situation where the other party is hurt because I've not done it properly. While non is I failed to act, and that has caused a hurt to somebody. So once again, some very good examples I'll quote once again so that it comes completely reinforces in your mind. For example, malfeasance. A standard example given by book is a city police officer uses excessive force during an arrest. So intentionally causing hurt. So if you read the CRPC or the BNSS, it is very clearly written there that a necessity wise or the necessary restraint has to happen when the police is arresting somebody or taking for a medical examination, or in that sake doing an interrogation. So if unnecessary restraint or unnecessary hurt is done, which is causing a death of a particular person or bringing that person to the suspect to the hospital, so in all those cases, this is case of malfeasance again. because this action constitutes malfeasance because it is an unlawful and performed with the intent to harm that person, which was not required. When we take example of misfeasance, same example, we talk about the doctors, and mostly this is doctors on which this is applicable. Non-feasance, for example, a landlord, we missed it yesterday also, we discussed it yesterday also, uh, has some property where he or she has not managed it well, where some broken tiles, some broken walls, some broken staircases are there, and somebody comes, falls, trips, and dies, or a doctor in an emergency situation is not helping a patient. So all those cases are examples are non-feasance. Let's talk about some case laws in all the three. So for the case of malfeasance, the very first one of it, the first case law we can talk about is RV, R for Rohit, V for Victory, Governor of Brixton Prison, Brixton, RV Governor of Brixton Prison, 1979. So this is the first case law about malfeasance. In this, the governor unlawfully detained a prisoner beyond their sentence and misapplying regulations. So it is required if a person who is a prisoner and who is imprisoned for a prescribed number of years or months to be in the jail, if the person is unlawfully detained further in the prison beyond that. So that unlawful detention was the matter in this case, RV, Governor of Brixton Prison. So RV is version, versus. So RV, so when I say V, every time you remember versus, it's easier for me to say. So RV, Governor of Brixton Prison, 1979. So the legal reasoning what was given here was the court held that such an action constituted malfeasance, as the wrongful detention was a clear breach of the prisoner's right. A prisoner who has completed his prison duration, the duration of the prison, is no more a prisoner. He is no more somebody who is convicted. He is a commoner. And then you cannot keep a commoner in the jail for further. But he did because of a malefice intention. And that is why the court called it a malfeasance situation. And the governor was held liable for unlawful depriving the prisoner of their liberty. Second case example is Baker v. Willoughby. V is for versus. Baker v. Willoughby. Willoughby. Baker v. Willoughby, 1970. Now, this is also a case law, but this is for misfeasance. So, misfeasance, a driver struck the claimant. So, claimant who is part of this trial, who claimed the relief, the driver struck the claimant, causing a leg injury, which was followed by a subsequent injury leading to amputation. So the injury was so harsh and so hard that the legs were amputated. So the legal reasoning by the court which was given was, the court found that the negligent driver was a substantial factor contributing to the outcome. He was supposed to follow certain rule. He was supposed to be not negligent on the street. He was not supposed to overspeed and to avoid damage to anybody while he was driving on the street, and which has caused this particular injury to the claimant. And in that case, this was considered a case of misfeasance by the court, and the driver was held liable for the damages incurred, and he was supposed to pay the compensation, and the punitive actions were initiated against the driver. Now, example of non-feasance case law is Home Office v. Dorset Yacht Company Limited. Home Office, V for versus. Dorset, D-O-R-S-E-T, Dorset Yacht is Y-A-C-H-T Company Limited of 1970. So this is a case of non-feasance. What is non-feasance? When you fail to act. So a group of boys escaping from a detention center managed by the Home Office caused damage to a yacht owned by a company. So the detention center staff had left the boys unsupervised, allowing them to escape and subsequently damage the yacht. So because the person was irresponsible, he did not follow his actions well, he did not put the right safety measures as prescribed, and he failed to act to ensure the kids are not running away from the house, and then they are creating some problem for somebody, which they created by damaging the owner of the yacht, which was owned by the company Dorset Yacht Company. So the court established that the Home Office had a clear duty of care, supervise the children properly. It could have resulted to damages to the children itself. So their failure to do so is considered a non-feasance, directly leading to a damage which was caused in this case, and there was a foreseeable risk of further harm also. It could happen. It could have happened that the accident might have worse, and somebody might have lost their life as well. So the Home Office was held liable for the damages incurred by the yacht company due to their negligence in the supervision. So that is where the 5 points, what is related to introduction and principles of liability in tort, is completed, where we say tort law serves as a vital framework. It's a civil wrong. It addresses civil wrong. It provides remedies primarily to the affected parties, the individuals. It clearly distinguishes between tort, contract, quasi-contracts, and crimes. And the three fundamental constituents of tort is wrongful act, damage, and remedy. And it is very crucial for establishing a liability, all these three elements, and understanding malfeasance, misfeasance, and non-feasance, which helps in categorizing the wrongful acts and assessing liability, which enhances clarity in legal disputes. So we are able to bring in exactly clear clarity to the presiding officer also, to help us and help them understand that it falls in which category. Okay. And that is how the malfeasance, misfeasance, and non-feasance helps us to categorize. Now, as I say, we'll first go to 3, then we'll go to 2. So this part of the subject, which discusses about the general defenses, the justification in an action for tort. So if you are somebody, Varad and Krisha, you are invisible. So Varad, so lecture on this particular part is what we're covering right now is for defense, hmm, which is justification. Now, if you are somebody, Varad, you are somebody, Krisha, if you are somebody who is supposed to be, who has made a tort, who has done, who has committed a tort, and you are somebody who is blamed to have done that wrong to the claimant, then what kind of defenses, what kind of justifications you can take? That is what is part of this particular part of discussion. So once we do this, then we are able to understand better the point 2. So the defendants. So what are you in this case? If one party is claimant, who are you? You are the defendant. So the defendant can raise various defenses. You can provide various excuses. I've not done this. I did not meant to do this. It was not in my control, and all those things you will come back and say. So these defenses or justification to counter the claims. Somebody has put a claim against you of $1 million or whatever it is. You are there to counter that claim brought against you, and that is what is covered in this chapter. To understand this defense, it is crucial for both the plaintiff and the defendant. Who is a plaintiff? The person who has brought along this particular petition. So this matter. So plaintiff and the defendant in the tort action, it is very much crucial for them to understand. They play significant role in determining the liability. So the more clearer your defenses are, the more creditable and the more credible your defenses are, the more credible your justification is, the more you are, discounted from the liabilities. So this is what we discuss in this particular part. So very first topic what we discussed is discuss in this particular module 3 is Volenti non-fit injuria, then consent, voluntary assumption of risk, and exclusion clauses. So the very first one is voluntary non-fit injuria. Voluntary non-fit injuria. Of course, this is a Latin term which translates to a willing person, injury is not done. The person who is willing to take that, to a person who is a willing, the injury is not done. So it serves as a defense against a liability for tort. Now, if the injured party consented to the risk or danger associated with an activity, I am not responsible for that. That is what voluntary non-fit injuria talks about. Second part is consent. In point one, the subpart is consent. So it is also similar. When a person voluntarily consents to a known risk, they cannot hold another party liable for resulting injuries. You are aware, you are clearly made aware of all the risks. Still, you wanted to participate in that activity and you cannot make me liable for that. So the consent must be informed and given freely. That has to be proven by you that it was given. You clearly informed of all the things which could happen and it was given freely. Point 3 under point 1 is subpoint 3 is voluntary assumption of risk. Now, often associated with a recreational activities, speed boating, bungee jump. So this defense applies when individuals engage into activities knowing that the potential risks are there. The person who jumps from a 500 feet or a 50 feet building, tying a rope on their feet, they very well know there might be risks. He might meet with an accident, the rope may break and anything, or in spite of every precaution, anything can happen. So they have voluntary assumption of the risk. They know this is very risky, but they have done that. And the exclusion clauses. For example, these are the contractual terms that aim to limit or exclude liability. So I'll come back and say in certain situations, so and so is the risk. And if this happens, this is an exclusion clause, I'm not liable for that. So there must be reasonable but and clearly stated to be enforced. It's not it's written in a word in a way where it is not, I'm not able to understand it. It's not very clearly written in simple atomic statements, or it is not reasonable also. If it is something not reasonable, then of course it cannot be acceptable. So basically, these are the 4 key concepts we discuss in point 1, which is voluntary non-fit injuria, where to a willing person injury is not done, a consent, a voluntary assumption of risk, and exclusion clauses, which is already in place before the accident or that particular incident has happened. Let's talk about the case laws to understand it better. So the very first case law for the point, voluntary non-fit injuria, is the Wooldridge, Wooldridge, Wooldridge versus Wooldridge v. Sumner. V is for versus. So Wooldridge v. Sumner, Sumner. Wooldridge v. Sumner, 1963. Now, this is an example case law for voluntary non-fit injuria, which says to a willing person, injury is not done. In a horse riding, this is related to horse riding case, a spectator, the person who was watching that horse riding, was injured when a horse bolted after being frightened. Now, the spectator had been watching the event, aware of the risk involved. This is similar situation for a racing car also, or a racing bike also. So the horse was riding, the person was watching that, he was a spectator watching the horse ride and the race, and suddenly a horse bolted and after being frightened, he jumped, which injured the spectator, who went ahead and filed a tort, instituted a matter of tort against the defendants. So the courts held that the spectator, having voluntarily assumed the risk associated with the horse riding event, he could not claim a damage because it's an animal which is running on the racing track, and the nature and the behavior of any animal could not be predictable. And in what situation it can go up to what extent, the person is very well aware. And that is something which is a calculated risk, or a willing person takes an injury is not done is applicable. And the defense to voluntary non-fit injuria was implemented and it was successfully applied in this matter, and the defendant was relieved of the liability. So there was no liability of the defendant because it was not his fault. So another example case law is for exclusion clauses. Okay. Why we are not giving case laws for another two is basically there are plenty of them, and the consent which you do give for a known risk. For example, you go ahead and you give a consent for a known risk of going for a scuba diving. Normally, they ask you to sign a small paper in certain places, right? So that is a consent, and if you go ahead and you do it, and there is something which is happening to you are an amateur. You know what are the risks to be within the water. You know you have not been trained and practiced doing the scuba diving until so many years of your life. Suddenly, if you want to do that, and you definitely understand the risk out of it. This is also something which is considered from the uh, um, medical side as well. If you see when a surgery happens, huh, when a smallest of procedure happens, even a dental procedure, you have to sign a consent form. Why? Because all the medical facilities and all the medical activities which are done, all the procedures which are done, they all have risks aligned with. Even a small surgery on your gums or the teeth, tooth as well, has a risk. So this is a risk which you consent to take, and you cannot claim for a damage in this case. Voluntary assumption of risk, you go to a amusement park, you run a ferry wheel, you run, multiple such games you play, which could be very risky. You do bungee jumping, you do a vertical jump. So all those things are very risky, and it is considered, if you read the tickets well, it is already written there. It's a voluntary assumption of risk. Anything happening with you not following any of the instruction, or in something which is not in control of their quality checks or God's act of God, this is something you are not liable to come for and ask for any compensation for that. So these are the basic examples for voluntary. But the famous case law for exclusion clause is there, where you exclude yourself. So this is something through a contract. So Photo Productions Limited versus Securicor Transport Limited. Securicor, Securicor. So Photo Productions Limited versus Securicor Transport Limited, 1980. So the facts of the matter is a security company's employee accidentally caused a fire that destroyed the property. Now, the contract included an exclusion clause limiting liability for negligence. So there was already a contract which was signed in that case where anything happening because of negligence was covered. Now, the court affirmed that the exclusion clause was effective because it was part of an agreement made between the two parties with a proper understanding under a contract, and the liability was successfully excluded because of the enforceable exclusion clause in the contract, and which was reasonable. So this is about voluntary non-fit injuria, consent, voluntary assumption of risk, and exclusion clauses. Another defense or justification could be vis major, which is act of God. You have no control. It's a natural event which is beyond human control, that cannot be anticipated. You don't know when it's going to happen. It cannot be avoided. You can't avoid it because when it has happened, it will happen. So these kind of acts are called acts of God, tsunami, earthquake, and whatever, lightning strike, so floods and any other natural disaster. So all these disasters, what happen, this is all the disasters are considered as act of God. So it's a general thing in all the agreements also. If you see in all the contracts, normally they say acts of God is excluded. So if something I'm not able to uh, complete the contract also, because of some act of God, which is reasonable and which could be explained and proved, I'm not responsible for the damages or the delays. So famous case example is Nicholas versus Marsland. Nicholas, Nichols, Nichols Nichols versus Marsland, 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 1876. So in this case, the defendant's artificial lake overflowed during a severe storm, flooding a neighboring property. So he had created an artificial lake, which was under all the right regulations. With permission, it was created, and the artificial lake was being managed properly with all the parameters in control as per the various controls and regulations. But suddenly there was a storm, severe storm, and the water flooded the neighboring property. The neighbor went ahead and instated a suit against him, and the court established that the flooding, which was caused by an exceptional natural event, a storm which was unforeseeable, which was not even something which was covered under the regulation as one of the control. If this happens, then you should have this or that. So in that case, it was an unforeseeable situation and not due to any wrongdoing by the defendant. It was not his will, or it was not him doing it for some reason, willfully and willfully to him, causing some kind of injury. So the defense of the uh, defense was accepted of vis major, which is act of God, and the defendant was relieved of the liability, which was beyond their control. So this is about vis major. This is also one of the defenses which is normally part of any contract. If you see any contract, it is always written there. Inevitable accident. As the word says, it's inevitable, an accident. So an inevitable accident, which I have not planned, which is not possible to, avoid, and that happens, this accident, if happens, and an event leads to damage or injury because of this inevitable accident, and the harm could not be prevented by the exercise of reasonable care. So drinking drive is not inevitable accident, huh? Because a reasonable care was not taken. Somebody was drunk, intoxicated, and driving. It is not an inevitable accident. So let's talk about one case law to understand that is Mason versus Mason v for versus Levy Auto Parts of London Limited. Levy Levy Auto Parts of London Limited, 1967. So it was because of a mechanical failure. It was not even a part which has failed, which was defective. It was an accident because some kind of mechanical failure which could not have been predicted despite regular maintenance. So maintenance was fine, parts was fine. Only thing what happened was an accident has happened due to mechanical failure. There is always a certain degree of failure, which is always acceptable in running of such machines because machines do fail. So the court found that the accident was inevitable because no failure on taking the proper care of was on from the driver side. Driver had taken proper care of driving in the right speed, in the right lane, with a proper training, etc., and a license. And he was completely in his senses, in his health, and there was no intoxication, etc. It was only suddenly because of an inevitable accident which has happened because of a mechanical failure. This accident happened. So the claim was dismissed, and the principle that inevitable accidents do not result in liability was established after that. So inevitable accident is also one of the principles which could be a very good defense. Act of third parties. Now, this refers to situations where an injury or damage is caused not directly by the defendant's action, but by someone else's wrongful act or negligence. Somebody else has done something because of which I failed, and that is why this has happened. This is that situation, act of third parties. Let's see the case law around that, which will explain us better, is Elliott, E for elephant, Liott, Elliott, V for versus, Elliott versus KNL Limited of 1972. So a driver was involved in an accident caused when a third party vehicle collided into him as he was making a turn, a proper turn. So the court ruled that the defendant could not be held liable because the injury was caused by a third party action completely outside the control of the defendant. It was not even in his control. Forget about thoughts. It was not under his control. So the court found in favor of the defendant as the act of third party negated liability. So his liability was taken away. He was one of the parties who was considered to be liable. He was held clean and acquitted out of it. So basically, the accident happened, but it was a third party's liability, not his liability. So this is also one of the good defenses. Novus actus interveniens. New act intervening. Novus actus interveniens is new act intervening. What does it mean? A new intervening act that breaks the chain of causation between a defendant's action and the harm suffered by the plaintiff. This concept is essential in determining liability when subsequent actions significantly alter the outcome of the situation. So a new intervening act is action here. So a new intervening action has come which has broke the chain of causation. So which has broke the chain of causation between a defendant action and the harm suffered by the plaintiff. Something has been introduced in between, and that essential in determining liability when subsequent actions significantly alter the outcome of a situation. Let's understand with an example. So case law. Knightley V is for versus Knightley versus John Hugson. Knightley is Knighley, Knighley, Knightley versus John Hugson, Hughson Limited, 1983. So a police officer and a driver, both of them suffered injuries after a motorcycle collided with a car. The motorcycle accident was initially caused by the defendant's negligence. However, the officer directed traffic in such a way that led to the subsequent crash. So this police officer and the driver both suffered injury after the motorcycle collided with a car. So this motorcycle goes and collides with the car, and both the driver and the police officer are injured. The motorcycle accident was initially caused by the defendant's negligence, but the officer directed the traffic in such a way that led to the subsequent crash. He directed the traffic in such a way, all of them collided. So the court found that the police officer's action constituted a novus actus intervenens, which means a new kind of intervening action has come, breaking the chain of causation. So the officer's decision to contravene standard procedure contributed to the accident, and the defendant was not liable for the injuries sustained by the officer due to the intervening act. Okay, so it was considered that the defendant was not liable for the injuries sustained by the officer due to the intervening act. It is something, an act which came in between this act of handling the traffic in a wrong way, we can say, which his signaling the traffic in a wrong way is something which is an intervening new act which came in and which triggered the chain of action, a chain of incident in a way that the causation which was supposed to happen where the car should have passed, the bike should have crossed, and everyone could have been on a fine foot and happy and healthy because of this initiation of the traffic police. Why he has introduced something in between which has changed the chain of causation and caused into colliding of the car and the bike, and that is how the accident happened. Another case example could be in the same thing for novus actus interveniens. The other example could be Robinson versus the post office. Robinson v. the post office. V is for versus. 1974. So a postman was injured. A postman who was delivering the letter was injured while delivering mail when a third party car crashed into him after having been negligently driven by a defendant. So postman was injured, he was delivering a mail, a third party car for no reason comes and crashes into him after being negligently driven by the defendant. Now, the court found that the initial negligence started the sequence of event. The subsequent independent actions of the driver of the car effectively broke the chain of the causation that began with the defendant's negligence, and the defendant was not held liable for the injury sustained due to the new act intervening. So it was something I would suggest all of you and go ahead and read this full matter, the Robinson versus the Post Office, which is a very good example to understand this point of Novus actus intervenens. Once you read it in the next class, you tell me what you understood. Okay, this is a very good case to understand because Novus actus intervenens is a little bit confusing topic. And this is the first case law not, but the second case law is very, very interesting. And if you read it, it will help you. If you do some research on the topic, it will help you to understand it better. So read this case law, Robinson versus the Post Office 1974. It's a very interesting case, and earlier case laws were not very long. So it's easy to read also. So read this one. The next point is plaintiff's wrong or default. Now, this is another defense or justification based on the plaintiff's wrongdoing or default occur when the plaintiff's own action contribute to or cause the harm they suffered. This can significantly impact their ability to claim remedies, right? So it is something where the plaintiff himself or herself has contributed to the damages. So their own wrongdoing or default which has occurred, which is when the plaintiff's own actions has contributed or caused to the harm. Let's take a case law to understand. It's McHale, M-C-H-A-L-E, McHale, V for versus Watson, 1966. So McHale versus Watson. A boy was playing with a slingshot. You know slingshot? It's a Y-shaped wooden structure where there's a band in between and you pull some stone or some stuff in between and leave it back because of the elasticity of the rubber. The whatever object you've kept here will fly in a projectile motion. So the boy was playing with a slingshot, accidentally hit a plaintiff in the eye. So the plaintiff was going there, the boy was playing with a slingshot, it hits his eye, causing injury. The plaintiff was partly responsible for being in a place where he could be stuck. Where he could be stuck. So plaintiff was partly responsible because tomorrow, if a different example, if I give, there is an example of Mumbai one shooting range, which happened a couple of years back. The person was very well aware there is a police training center and a shooting range. And there is a grace space which has to be left and not occupied. Because in the shooting range, when they shoot the guns on the mark, the shots might not hit the target. It might go beyond that and they fly up to a certain meters and kilometers and then they drop. So this person was very well aware of that. In spite of that, he went ahead and put a tent there for some celebration and function. By God's grace, unfortunately, and by God's grace both, only one person was hit in that fatally and that person passed away. Other host of bullets which came that side, fortunately hit some other part in the tent. People were not shot, but one person was shot here between the eyebrows. So the claim when he went to make in the court, it was failed because he was in the buffer zone of the shooting range, making his tent and enjoying a party there. So similar example, the plaintiff was aware the kids are playing there with slingshot. There is quite a chance he might get a hit somewhere on the body. So plaintiff was partially responsible for being in a place where he could be stuck. So the court noted that the plaintiff's own action, for example, standing near the boy, in front of the boys who are shooting slingshots, contributed to his injury, thereby affecting liability. The liability is impacted. His claim was dismissed because his own default uh, in failing to avoid the situation. It happens similarly in the vehicular accidents also. In vehicular accidents also, motor vehicle accidents also, if there is an accident happening between two vehicles, it is equal responsibility for both the vehicles to avoid the accident. If you see some vehicle coming very fast and you are in a small vehicle and just for some fun or maybe some other reason, if you're trying to annoy that car just in the track and try to stop, and you stand in between knowingly the car is coming at a very high speed, you come and stand in the front, watching some Bollywood movie, and you say, boss, I will make him stop, and he's unable to stop and you get hit by the car, you are also equally wrong. So the Motor Vehicle Act also runs on the principle of the same, which is plaintiff's wrong or default. Another case law for the same topic would be Graham, 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 Ellis, 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 V for versus Hartlepool, single word, Hartlepool, Hartlepool, 1997. So Graham, Ellis versus Hartlepool. So a cyclist was injured when he fell from his cycle lane during a race. Evidence showed that he was competing recklessly. So the court recognized that the cyclist's own reckless behavior contributed to his injury. So he was running in the track in this matter in a lane, and he tried to overshoot by means which were reckless, trying to jump over the stone or the line which was there for dividing between the people watching and the racing track. So he jumped in between, and that's what it caused the injury to him. And the defense argued that he could not claim damages since he was responsible for the accident. He himself caused it. It was not because of the organizers. It was not because the racing track was not properly managed. It was not because some default or the breakage was on the racing track. It was not because of any other such reason or parties which has caused damage. He was responsible for himself. And that is why the damages were denied. The reverse and the similar also could be the cases in the motor vehicle again. So if you're driving a bike on the street, if you're not wearing a helmet and you're running, zigzag, and you might meet with an accident, who is responsible? Plaintiff's own wrong or default. But if there is a speed breaker which is suddenly made and not as per the parameters given by the government, it is not painted, and in the early wee morning somebody is going on a reasonable speed and suddenly skids on that speed breaker because it was not there yesterday, it is not colored, it is not of the correct specification, the person is injured or dies, it is not his fault. So then that defense cannot happen against that person who has suffered the injury. But in the previous case, it is. So plaintiff's wrong or default could also be a very good defense and justification. Next is self-defense and defense of property. So everybody knows that in the law, self-defense is allowed up to a reasonable extent. There are very famous case laws in IPC, BNS around that, where up to what extent you have to attack or counter-attack somebody to safeguard yourself. You cannot attack to an extent beyond that. That has to be determined very closely and very finely in the court of law. So self-defense allows individuals to use reasonable force to protect themselves from an imminent harm. So any harm which is you see coming up to you, and to safeguard yourself, you are allowed to take care of that imminent harm, and you are allowed to take a reasonable force to protect yourself. So self-defense is use of a force, a counter force. Similarly, defense of property, your vehicle, your house, is a reasonable force to protect one's property from unauthorized interference. Let's take a case example. V is for versus, R versus Gladstone, single word, Gladstone, Gladstone, Gladstone Williams, V for versus Gladstone Williams, 1984. The facts of the case. The Williams intervened in what he perceived to be an assault on a youth. He used force to protect the youth, but the situation turned out to be different. So he thought the youth were fighting, and there is an assault happening on one of the youth. And he used force to protect the youth. He went ahead and protected the youth. And the situation turned out to be different. So the court determined that Williams had a right to defend what he reasonably believed. It was reasonable. He has no reason of any enmity with them. He was not even aware of them. There was no history of him doing that. So there was no other reason reasonable which could explain why a reasonable person would act that way. So that person had a right to defend what he reasonably believed was someone in danger. And even if the threat was not real, it came out to be later. But on the prima facie, the first look of it, it was looking like a uh, threat, which was not actually real. So the key aspect was the reasonable perception of the threat. The court ruled in favor of Williams, and whatever the conduct he has done, it falls under justifiable self-defense. It has really happened in one of the I don't remember the cities in India, where when shooting was happening and a girl was being teased by the actor, the person coming from different side did not perceive it to be a shooting. He went ahead and slapped the actor. So these things in a very different flavor and situation can happen. But if there is a really a justifiable reason in which it could be justified, the act was done not to harm, and no tortious action has been has happened. It was just because of a just and the reasonable reason the person has acted. So that can be a good defense, and that's a good defense and justification by the defendant to be coming out of taking out as a defense for the tort liability. Another case example for the same, which is self-defense and defense of property, is uh, Hingston versus Timmons. Hingston, Hingston. Hingston, V stands for versus. Timmons, Timmons. Hingston versus Timmons. It is 1939. In this case, a property owner used a force to reject a trespasser from their land. The trespasser claimed injury as a result. So he was trespassing into his property, and when he challenged him, he declined to move out of the property. And what he did is the defendant, he forcefully throwed him out of his property, which had claimed injury to the plaintiff. Now the court acknowledged that the property owner's right to defend their property against any intrusion, any unauthorized access or use, or any entry is proportionate force was deemed reasonable. It was a unauthorized entry which was happening. It was right of the property owner to ensure that no access happens unauthorized, and the use of the force what had happened at that point of time was reasonable. He was pushed out of the property, and if he fell down and got an injury, that is something which is not unreasonable on part of the defendant, and the court ruled out for the property owner, affirming that the defense of the property was justified in the case and no improper force was applied. In that case, the judgment was in favor of the defendant, because there was no reason he could have done that. There was no intention to do that. And it was because of the self-defense or the defense of the property that the person has acted, which is considered a valid defense and justification. Next defense could be necessity. So defense of necessity allows for action that would ordinarily be considered wrongful. They are taken to prevent greater harm. For a greater harm, if I have to save because of necessity, I can do some action, and this defense asserts that the individuals can engage in actions that infringe on others' right if those actions prevent imminent and serious harm. Take an example of Fuldus versus Willoughby. Foulds, Fuldus, V versus Willoughby. WILLOUGHBY 1841. Fuldus versus Willoughby. The defendant cut down the plaintiff's tree to prevent his house from catching fire from another person's property. the court concluded that the action taken were justifiable as a necessity to prevent a harm. The defense of necessity was upheld. It was necessary for him to cut down the plaintiff's tree to prevent his house from catching fire from another person's property. So this necessity was upheld by the court, recognizing that the defendant acted to prevent a significant threat to his property, even at the expense of plaintiff's rights. This is also inclusive of defense of property. So it was a necessity for him to definitely ensure the tree which had caught fire in between and it was inclined towards his house. There was quite a possibility that because of plaintiff's house was here, his house was here, and the third person's house was here. So A, plaintiff, B is the defendant, C's house, because of his house, a fire started on this tree. This tree was landed almost, inclined towards defendant's house, and he saw the fire on the tree. It was definitely a plaintiff's tree. He went ahead and chopped down the tree to ensure it is falling down on the grounds, and the risk of getting fire into his own property, damaging is safeguarded. So it was a necessity which was considered, that this necessity was a necessity to ensure the protection of his own property. This is also an example of defense of property. Take another example for necessity. It's called REF. REF as a separate alphabet. Mental patient sterilization of 1990. So this case involved a mentally incapable individual for whom medical professionals sought to perform a sterilization procedure to prevent further pregnancies that could pose a risk to her health. So the lady was mentally unwell, and the doctors thought of doing a sterilization so that as she is not mentally well, she might not know how to resist and how to safeguard her from a pregnancy which could happen, and that is why she was forcefully sterilized. Now the court recognized that the medical procedure was necessary to protect the individual's health and well-being despite potential legal consequences, because you're doing it to somebody who is not able to give you a consent, and you're doing it. The necessity defense was invoked to justify the medical intervention that was performed with the individual's consent due to her incapacity, without her consent due to her incapacity. So it ruled in the favor of the medical professionals, and the sterilization was allowed on grounds of necessity. The recognition in the safety and security of the women's safety and security of the women is a concept which was not very much popular earlier in the time when people were concerned about that, but very strong means policing policies were not there at that point of time. So it was probably at that point of time, in that situation, for those situations, it was also not, some facilities were not there to protect the woman also, this woman also, from, getting into such a scenario where she might have get into a situation of any pregnancy which is which could have happened to that lady. So in that case, the court ruled that it is okay, because of this particular necessity of protecting her from getting into further medical complication because of pregnancies, it is allowed to sterilize her. So this is a case law for necessity again. Now, statutory authority. This is one of the defense, and this is a default defense. It is a defense everywhere. In fact, in the various criminal laws also, there are statutory authorities and there are government officials who are discharged of whatever the activities happen during the line of the duty. So similarly, in statutory authority, the defense of statutory authority applies when an individual's actions, which may be considered tortious, are performed under authority of a state statute, a law. The act is authorized by a law. the individual may not be held responsible for or liable for the tortious act resulting from the execution of that authority. If the person is authorized to that particular activity under statute, and then the person cannot be held liable for that. For example, case law 1, which is Goringe, Gorring, Goringe v. for versus Calderdale, Calderdale, MBC, Goringe versus Calderdale, MBC, 2004. So the council erected a road sign indicating an improper route leading to an accident. The council was accused of negligence for failing to provide adequate warning. Now, the court assessed whether the council acted within its statutory authority concerning road safety. The council argued that they were acting under the specific powers given to them by legislation governing road management. The court ruled in favor of the council, recognizing that their actions were justified under statutory authority, limiting liability for the accident. So what they did was, from the perspective of whatever the legislation has given the powers to them related to governing road management, but they were not liable for the road sign improperly giving any or indicating any improper route or etc. It was not their role, and that is why the statutory authority limiting to their particular actions related to their own work, which is not spanning to that particular area of the work where it was supposed to take care of the risks or the proper design and direction on the boards, they were discharged by the court from the tortious activity, the blame of the tortious activity. Next example is PPS Electrical Service, versus NEL 1975. A utility company, a power company, which is called as utility company, water supply, power supply, these are utilities. So utility companies employ damaged private property while repairing a power line under their statutory duties. So they were working on a high tension power line, and while repairing the high tension power line, damaged the private property in between. So it was determined that the action causing damage was necessary for fulfilling statutory obligations related to public safety and service provision. So if it is required that way, which if not done would have impacted a lot of commoners, public. So the court ruled out that the utility company was not liable for damages since the actions were authorized under statutory duty. If doing that, there is a side effect which has happened, which is fine. Then judicial and quasi-judicial acts is another defense. So judicial and quasi-judicial acts are action taken by judges, which is judicial, or authorized bodies that have legal authorities. These actions carry an immunity from liability for tort if conducted within the scope of their lawful duties and without malice. So, for example, if the COVID time, if the vaccines were being given by the medical professionals in line of the permission and approval and order from the government, and if something side effect has happened because of the COVID vaccine, it was not unlawful action on part of the people providing and giving the shots of vaccine. The various laboratories and clinics, it is not there. They don't come under tort in that situation, because this action they were authorized to do and issue the certificate on the government certificate. So the actions carry an immunity from liability for tort. They could come back and sue the government. They can come back and sue the vaccine company, but they could not come back and sue the company which is taken contract from the government under the instruction and authorization of the government and doing that vaccination, or the judges, the action taken by judges. So these are a good defense and justification. For example, Crown Proceedings Act 1947. Crown Proceedings Act of 1947. This legislation outlined the protection for public officials and judges regarding claims for negligence or other torts related to acts performed in the courses of their duty. So the Act recognized that the public officials need protection from personal liability while performing their responsibilities to ensure that they can fulfill the duties without fear of legal repercussions. And the court upheld that the immunity provision, demonstrating the judicial actions taken in good faith. In the with good faith when it is done, it's done in a for purpose of common good. In the course of official duties, cannot be subject to tort claims. So it cannot be. Even the lawyers, when they practice and they fail in a matter, the clients cannot bring a suit against them because they failed, because they have put the right effort depending upon the knowledge. They themselves have selected that advocate by interviewing the advocate and talking to the advocate, by probably hearing for somebody or probably meeting the advocate and getting convinced. And in that case, the advocate is also as per the current prevailing laws, is out of the any kind of such kind of tortious liability or even consumer acts. So failure will not make a person to drag an advocate to a consumer court until and unless there is something in general very visible delinquency done. Case example, another one is Murray versus BBC, Murray v BBC of 2008. The plaintiff alleged defamation against the BBC broadcasting company and overstatements made in a documentary. Now, the BBC claimed its reporters were exercising quasi-judicial function in their investigation reporting. So they were doing it with all the good faith, for all the good purpose, using the right procedures, using the right techniques without getting into an unfair mean, and gathering information and converting it into a documentary report. The court analyzed whether the actions of the BBC constituted a quasi-judicial act warranting immunity from liability. And then the ruling noted that while media outlets have responsibilities, protections may exist when actions are taken in the exercise of legal duties, illustrating the balance between media freedom and individual right, and it went in favor of the BBC. Next is parental and quasi-parental authorities. Now, this defense applies when parents or guardians are held liable for the actions of their children or wards. Now, you can use it for your parents. The law acknowledges the role of parents in guiding the behavior of minors while granting certain immunities when acting within the bounds of their authority to control their children. So their behavior, the law acknowledges that the role of parent in guiding the behavior of the minors while granting certain immunities, they are protected, well protected, when acting within the bounds of their authority to control their children. So certain immunity is given, and when acting within that bounds of their authority to control their children. So tomorrow, if you have you get a lesser mark in your law papers, you can come back and say give this defense, parental and quasi-parental authority defense. So listen it well then. The case is Gillick versus Gillick, Gillick, Gillick versus West Norfolk, West, second word is Norfolk, 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 and Wishbeck, Wisbech, Wishbeck Area Health Authority, 1986. A mother challenged the authority of doctors to provide contraceptive advice to her underage daughter without her consent. Now, the House of Lords held that the parents have a role to play in the legal rights of minors, with children gaining capacity to make decisions independently under certain conditions. So the case affirmed that a parental authority must be understood within the context of the child's evolving capacities and right, and it might be a defense where probably in spite of this, a child might have got in a discussion and might have required that, and it was then held in favor of the doctors. Second case law is Hoffman versus WN and F. Hoffman, Hoffman, Hoffman versus V. WN and F, 1967. A minor caused damage while riding a bicycle, and the parents were sued for negligence in allowing the child to ride without supervision. So the court assessed whether the parents exercised reasonable care in overseeing their child's behavior, considering their responsibility as guardian. Now, the question was whether the parents had fulfilled their duty of care regarding the actions of the child. So, duty of care again. So, the court ruled that while parents have a duty to supervise their children, the extent to this duty must consider the child's age and maturity. In this case, the parents are not held liable as the supervision they provided was deemed reasonable given to circumstances, reflecting the balance of the parental authority with reasonable expectations. So you cannot keep running when your child becomes a 15-year-old or 12-year-old. When the child was 5-year-old, you were running with the child, holding his or her cycle and running along with them on the track. Very good, fine. But you cannot be made liable if the child grows at 12 years of age and with the same training goes and crashes into somebody. It's not your default. So this is a parental and quasi-parental authority related case law which we just discussed. The last two topics are illegality and mistake. So that this is again a defense of illegality. The defense of illegality, which is asserts that a plaintiff should not be allowed to pursue a legal remedy if it arises from an illegal act. So if it is arising from an illegal act, the person is not allowed to pursue a legal remedy. This principle maintains that one cannot seek legal redressal for a wrong that is itself rooted in unlawful conduct. So tomorrow, if somebody is taking drugs, some kind of contraband, narcotics, he takes from a supplier. One day the supplier gives him a drug which is causing him health issues. Can the person go to the police and say, I'm buying these drugs and this drug has got side effect to me this time because it was of not good quality? You cannot do that, right? So this is something which is arising from your own illegal act. Take a case law of Gray versus Thames Trains Limited. Gray, Gray, Gray versus V, that is V. Thames, Thames, Thames Trains Limited. Three words. Gray V for versus Thames Trains Limited of 2009. The claimant was involved in an accident caused by a train while he was trespassing on the tracks illegally. He later sought damages for injuries sustained in the accident. For your kind information, in such scenarios, if on the railway crossings, somebody is crossing the railway crossing, which is closed for the public to cross because a train is going to pass, and a person is crossing with a bike, cycle, or running across and gets hit by a train, on the same particular legality clause, the insurance companies also decline all the claims. So legality is a very important defense in terms of uh, disowning the tortious claim by the defendant. So the House of Lords held that since the claim arose directly from an illegal conduct, trespassing a railway line is an illegal trespass, the plaintiff could not recover damages. The defense of illegality barred the claimant from seeking relief, and the claim was dismissed on the grounds of the extirpi. It is called extirpi causa non-oritur action. Actio. Extirpi causa non-oritur, O-R-I-T-U-R, oritur actio, A-T-I-O. So any accident caused by any action, any injury caused by illegal action cannot be used to seek a legal remedy. And that is again one reason on basis of which a person who is done his life insurance, if the person commits a suicide, the insurance claim cannot be settled. Because he has done an illegal action of taking away his own precious life. Case example 2 for illegality is revel Revill. Revel V for versus Newberry, Neewber by single word, Newber by 1996. So in this case, a man attempt to burgle a shed and was shot in the process by the property owner. So he went into a shed, a place where people store things, and he tried to burgle. He was conducting a burglary and he was shot in the process by the property owner. The burglar sought damages for injuries sustained during the burglary. So, quite clear. The court found that the plaintiff involved in illegal activity. So, if somebody tomorrow in your house, a thief comes in and he tries to do some theft in your apartment or house, and then your papa or your mummy goes there and beats him black and blue, and then tomorrow, do you expect him going to the police station, the thief, and saying, "Boss, I want to file a complaint because he has beaten me in black and blue because I was coming there for a theft and I need a claim for settlement of my medical issues because which has caused because of his beating me." So the court found the plaintiff involved in a illegal activity, burglary. How come you can commit burglary and then you can come back for a tortious claim against the person who has shot you, whom you are trying to burgle? So they could not seek a compensation for injuries incurred during that crime. In fact, the person should be arrested or fined. The claim was denied, emphasizing that one cannot benefit from their unlawful action. Okay. So this is something which is, for example, you're caught in the examination red-handed cheating. So when you are doing a cheating and you are restigated from the college or barred from the exam for that particular session, you just cannot come back and ask for compensation to the college saying, "Boss, I lost my year." If as per the policies of the university, if the college has done action right, it is done. So last defense is mistake. The defense of mistake can happen by anyone, right? Applies when a party seeks tort relief but is unable to establish liability due to a fundamental misunderstanding or error regarding facts relevant to the situation. Okay, let's see one example. R versus A, RVA, R versus A of 2000, sorry. So in this case, the defendant was charged with sexual offense against an underage individual, claiming a mistake regarding the person's age during the incident. The court reviewed the defense of mistake to assess whether the defendant's belief was reasonable under the circumstances. The court recognized that if the belief of the age was honestly held and reasonable, it could negate the criminal liability. However, in tort, the same principles applied where a mistake belief pertaining to legal responsibilities can impact claims. So, in this particular matter, in 2000, the British House of Lords was in favor of the person, but it is not the case in India. In India, it is considered that you are somebody, if you are getting into a relationship with a chances of, you yourself know your age, you are major or minor. If you are major and if you are seemingly making a relationship which is which is not allowed with a minor, in that case, if you are getting into that kind of relationship, there is no excuse for you of mistake in India. You are supposed to find and ensure yourself seeing the reasonable documents and ensure the person is not minor. Otherwise, you will be held under POCSO Act. So mistake is, in terms of sexual activities in India, it is not tenable. Coming to the case example, next one. And this is both sides. This is for boys versus girl, girl versus boys. Next case example is Fitzgerald versus Lane and Patel. Fitzgerald, 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 V for versus Lane, Lane, and Patel, 1998. Now, during a traffic incident, a driver failed to notice the plaintiff due to distractions, resulting in an accident. The defendant later claimed they were misled by the action of the other driver. So the court examined whether the defendant's mistaken assumption was reasonable in the situation. The court emphasized the concept that mistaken beliefs acting the understanding of reasonable care can influence liability in the tort, and the driver was not considered in making a mistake. I'll tell you one live example which happens every day on the streets of India, and it is happening a lot of times in the outskirts of Pune also, which is related to motor vehicle and which is related to mistake, where a bus or car driver, bus or truck driver, mostly those cement trucks you have seen, the ones which carry the ready mix cement. So those are very huge trucks. And unfortunately, there is something called blind spot, which is recognized by law. So anybody, if coming behind the truck very close, not taking a reasonable, maintaining a reasonable distance for their own safety, if it is crushed below the rear wheels on the opposite side of the driver cannot be punished. This is considered a mistake because it's hardly possible for the driver to see a person on the other side of the driver rear wheel when the person is taking a turn on either of the side. So on this condition, a lot of claims of death, a lot of claims by the dead people, their families for the dead people is declined. A lot of punishments are not happening to those truck drivers because this is a reasonable mistake which is happening. Or you go and stand in front of a truck, which truck is very high. It is 6 feet, 10 feet high on the floor. And if you're very close to the truck, there is no sensor, there is no camera which the truck owner will see. It's your reasonability to ensure that you do not stand there, you stay clear. In those situations, if accident happens, it is considered under mistake and driver is not punished. Defendant is released of their guilt. So in this particular second part, what we discussed today, we have traversed the essential principle of all the essential principles of general defenses and justifications, which is very important to know. The first part, we understood how we differentiate and categorize the torts. How do we actually understand what is tort and classify that? Second part, today we have understood the justification. So this voluntary, non-fit injuria, consent, and exclusion clause, these are the very important waiving rights for willingly assumed risk. While vis major, which is act of God, and inevitable accident, the next one, 2 and 3, are good defense based on factors beyond control. Both of them are beyond control, emphasizing the contextual nature of tortious liability. It's context based. The even measurement is context based. It's unliquidated. Judicial and quasi-judicial acts reflect the protections afforded to individuals exercising their legal duties. While claims related to parental authority, statutory authority, principle of illegality address the responsibility and limitation of various parties under tort law, and acts of third party, Novus actus, intervenens, plaintiff's wrong or default, self-defense, defense property, necessity fall in a same category. So what we have understood today is section module 1 and 3. With that, we can understand module 2 tomorrow. Not tomorrow. I think you have seen the session or not. Let me stop the recording first. Then I'll